The second type is a third-party funded trust, and that's the most typical kind in estate planning situations. Mom and dad have two disabled children, two children, one is disabled, one is not. They do a will, everything to the spouse, and then the rest equally divided to the two children, with the disabled child's going into a third-party funded special needs trust. Now, in a third-party funded special needs trust, in Pennsylvania at least, there is no payback to the Department of Public Welfare. So that money goes to Jimmy, the disabled child, and then when Jimmy passes away, anything's left can pass however the trust states, whether it's to his children, whether it's to other siblings, whatever. There's no payback in Pennsylvania. Other states do have a payback. Pennsylvania does not. In the typical estate planning situation, you're going to have a third-party funded special needs trust, and it might take retirement benefits, it may take life insurance benefits, it may take part of the estate. But whatever it is, it needs to clearly designate that it goes to that third-party funded special needs trust. Now, there are times when you have to use both. Let's say it's an adult disabled child who lost his job, isn't likely to be able to hold a job, has $15,000 in savings, and you can only have $2,000 in savings and qualify for for medical assistance. So to get medical assistance or supplemental security income, you can't have more than $2,000 in the bank. So you want to take $13,000 of his $15,000 and put it in a special needs trust, a self-funded special needs trust. And then the family will have a third-party funded special needs trust to accept the money from the estate. Okay, so the disabled person's own money, if he has some, or it could be a personal injury case, it could be an inheritance of somebody who didn't know to put it in a special needs trust. Wherever the money is coming from that it's his, you put in a self-funded trust. You have to have the payback provision in there or it won't fly because it's his money. But where the family wants to leave money to him from the estate, from insurance, from retirement benefits, from wherever, then it's a third-party funded with no payback. So in the situation I've given you, where there's an adult child with some money, you're really going to need two trusts because you can't commingle the money. You need a self-funded trust for his own money, a third-party funded trust for the inheritance that he's about to get from the family or from the retirement plans or wherever. If you commingle the money, the department is going to say, we can't tell whose money got spent when. We want it all. Or at least you run that risk. So you really need, in a case where the disabled person has money of his or her own, you don't use one trust. You have to have two trusts, and you have to say in the trust it's either self-funded or third-party funded. That's really an important issue. Going back to the third-party funded trust for just a minute. When we draft those trusts for persons with disabilities, families come in, they want to leave their estate to their children, one of whom is disabled, and we draft the third-party funded special needs trust. We don't put those trusts in the wills. A lot of form books will show you to put those trusts as part of the will. I would encourage you not to do that. I would encourage you to have it as a separate document, standing alone, not as part of the will. And the primary reason for that is, well, there's a couple of reasons for it. One is that if other family members want to leave money to the disabled individual and the trust is in the will, well, of course, the trust has no legal effect until the individual has died. So there's nothing to really identify. You know, if I want to leave money to my disabled child and I put the special needs trust in my will, but my mother, the grandmother of the child, also wants to leave money to the disabled child, how do they identify it? They can say it's the special needs trust in the will of Dennis McAndrews, but that trust doesn't have any effect until I die. So put it in a separate document so that other family members can identify it easily and readily, and it exists now. If you put it in a separate document, it may be unfunded, but the trust exists upon its signing. So there's, I think far more utility putting it in a separate, trust agreement or deed of trust, however you want to term it, so that other people can leave money and so that it has immediate effect. And we've had, I can't tell you how many clients have been gratified to hear that, because we explain why we do it outside of the will. And inevitably the response is, oh yeah, my brother said he wanted to leave money to Jimmy, or my father wants to leave it. And it is just so much easier to manage that way. And the second thing is that probably a third to half of the states have started requiring paybacks from third-party funded trusts for medical assistance. Pennsylvania has not really had a lot of discussion about that happening, but it's always a risk that there could be a payback required from a third-party funded trust. And if it existed before the date of the new legislation, even if it's dry, you might get grandfathered in. So I think that's another benefit of having the trust in existence now, that if the Pennsylvania ever starts looking for paybacks from third-party funded trusts, you might get grandfathered. So that's a second benefit from it.